Welcome to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Today, it's Charles Hepworth. Charlie is universally recognized by fellow lawyers and clients as the leading Boise trial lawyer. No attorney in Idaho comes close to him for a record of success with medical malpractice cases. Charlie answers your questions about the law and how it affects you.
What is product liability?
So product liability is a term that refers to any product that is sold in the marketplace that causes an injury. That product failure that leads to an injury would be what the term product liability refers to. So again, let's just take a hip component case as an example of a product liability case. The hip component is the product. If that hip component fractures and it has to be removed and replaced, then that will result in liability on the part of the manufacturer that introduced into the marketplace a defective product that caused an injury for an individual who was the recipient of that product. So product liability refers to that situation. That would be an example.
How do I know if I've got a claim?
I think the answer is you would need to talk to a lawyer who specializes in product liability cases. Again, product liability cases are a specialized form of personal injury case, so you'd probably start with trying to identify a personal injury attorney and explain to that attorney that you think you have a product liability case, or you believe there was a product that failed that caused you substantial injury, and that attorney should then be able to tell you whether they have the expertise to help with that type of case, or if they don't, that attorney hopefully could refer you to a lawyer they know in the area who does have the expertise to help with that type of case.
So, Charlie, are there different types of product liability claims?
Certainly. They can range from medical products, like we've already talked about, to, let's say there's a conveyor belt that doesn't have the appropriate safety guards in place, and a worker suffers a serious injury because they are interacting with that conveyor belt and they suffer an injury related to the conveyor belt. So any product, whether it's a medical product or an industrial product or a car that, where an airbag fails and doesn't protect the occupant of the car as it's intended to, literally any product that fails that results in injury to an individual could be the basis for a product liability claim.
What kind of damages can I recover?
So the damages include, I would say, 3 categories in a medical malpractice or product liability case, both of which are just specialized forms of personal injury cases. So I'll refer to just personal injury cases. The types of damages typically would include medical expenses, both medical expenses incurred in the past, from the time of the incident up until the time of trial, as well as medical expenses projected into the future that the individual is reasonably likely to incur. So you recover medical expenses, you recover pain and suffering damages, which we refer to as non-economic damages. And oftentimes with personal injury cases, if the individual is a worker who has been injured, we will be able to recover disruption of earnings, and sometimes it's lost earnings from temporary displacement from a job, or in larger cases, it can be loss of earnings because that individual can't return to their normal job, and therefore the impact on their earning ability is very substantial. So those are the most common types of damages that are involved in personal injury cases.
So how do I afford an attorney to help me out here?
And most often with personal injury cases, an attorney provides their services pursuant to a contingent fee. And a contingent fee is a term that refers to circumstances where a lawyer will do the work on the case and the lawyer is not paid until the case is concluded, and the lawyer is paid a percentage of the final recovery in the case. If the case is lost, then the client owes nothing to the lawyer because the client is paying a percentage of the full of the ultimate recovery, not based on how much time the lawyer has spent. So the most common form of payment is a contingent fee arrangement, where it's a percentage of the recovery that is paid at the conclusion of the case.
Thanks for listening to Ask a Lawyer with the attorneys at Hepworth Holzer, life-changing law in Boise, Idaho. Join us next time as they answer your questions about the law and how it affects you. They can be reached at 208-343-7510 or hepworthholzer.com.